Hi everyone! Today we're going to talk a bit about online IP protection, and it's really the natural evolution of what we used to refer to as online brand protection, but as we today use all different type of IP tools from your IP toolbox, meaning patents, design, copyright, trademarks, etc. We find it more natural to talk about it from an online IP protection instead. And today I'm going to talk a bit about the overview from the different types of IP, so you maybe can get some ideas and learn how to use the different type of IP rights depending on your needs on your online enforcements. We can start with the most natural one, and the one that kind of have been part of these online brand protection programs since the day one, and it's the trademarks. And traditionally it was that type of IP right the whole program relied on, and we can see that it still plays a very important role in this aspect because it's a very efficient tool. You have the name. If the copy has the same name, you can enforce by using the trademark. It's also one of the prerequisites for driving domain name disputes. So it's both on marketplaces, but also when you have domain name abuse, which you want to enforce, that you can use your trademarks for. But moving away from the trademarks, because what we can see is that we sometimes enforce a lot by the trademarks, and then the infringement maker transitions away from the trademark, but they might still be selling your design or your technology. And that's where we get the design rights and patent rights, for example, to come into play. Oh, now let's talk a bit about patents. So patent rights can be used when, for example, the trademark, as in the previous example, when someone stops using the trademark but still selling the product that is infringing for you. Or it could of course be a competitor or a copycat, just sort of stealing your technology with pride and selling it online. I'm happy to see that both Alibaba Group, eBay and Amazon all have launched the possibilities to actually enforce by using patents. So you don't have to just rely on trademarks. But on other smaller marketplaces, or they can be big locally, but smaller in context to these three giants, there are limited possibilities to enforce your patent rights directly towards them. But you can still go to a local court and get a preliminary injunction and use that preliminary injunction also to enforce on their marketplaces. So there are quite a lot of also tools in the toolbox for patent enforcement online. One should know or keep in mind that when it's a trademark infringement, it's often quite straightforward for the marketplace to make a decision if it's an infringement or not, because what it says is your brand, and if it's an infringement, it has your brand on it, so it's quite easy for them to make that judgment. But for patents, it becomes often much more technical, and therefore you often need to use and rely on maybe a patent attorney that can help you describe what your patent is protecting and how that goods that is being sold on the marketplace actually infringing on the actual patent. But still, we have found it to be a very efficient tool to use, and we have seen great success, especially across Amazon, eBay and the Alibaba Group on these enforcements. Yes, so now into the design rights. And what you protect with a design is the look of a certain product. It could be really anything from some clothing to spare parts to on cars, for example. It's an efficient tool to have because the design right is also often very easy for both the marketplaces, but this one is also very good to use together with the customs, because it's very easy for them to have a look at what you have protected, how does this look, and how does the product look. And if they are similar, you have the design infringement. So for example, customs, they usually don't like to engage with patent rights, but design rights are much more welcome for them. And we keep on educating customs for many of our clients around the world, for them to understand our clients' products, what has been protected, and what they should look for when doing their work. So again, designs also a very good complement, and it's a quite straightforward IP right to be used. And And that one we can also see a wide acceptance around many marketplaces compared to the patents, for example. So now over to copyrights. And copyright is also a very efficient tool, because what we often see is that the infringement makers are using the real images, meaning the brand owner's images, to sell their own products, because they want to look as similar as possible to the one looking to buy the product. So as long as you can show or prove that it's your copyright, then you have a very efficient toolbox. And for example, in European Union, you have unregistered copyrights, but for other jurisdictions you might need to actually register your copyrights, and that we as a law firm can of course be part of helping you with. Now over to domain names, and a well-built domain name portfolio supports your online IP protection program. And on domain names it's twofolded. You both have sort of the brand protection part of the domain names to consider, but you also have the cybersecurity part to consider. And if you just take a moment to reflect on the cybersecurity part, one can see that the majority of the cybersecurity incidents and attacks that happens starts often with a domain name registered by a third party. So to work closely with IT as well on your domain name portfolio is also important. Now back to more of the online brand protection part or online IP protection part of the domain name portfolio. By leveraging your domain names and your trademarks, you can build a quite efficient domain name portfolio, both from a cost perspective, but also from a protection perspective. So let me exemplify that for you in a few examples. If you see in your online IP protection program that you're running that, let's say in China, you have a lot of online infringements happening. So although you have the trademarks registered, which would be sort of needed to take back a registered domain name by a third party, you might still want to apply a quite broad proactive registration strategy in that specific country. While at the same time, if you take maybe the neighbor country Japan, you see that we have a lot less online infringements here. Then you don't need to apply the same strategy for that specific market. Here instead you can be much more selective and balanced on which domain names you register, as long as you have the right trademark protection in the background. We see a lot of these different nuances and things to consider for your domain name portfolio. In most countries you have these good dispute resolutions in place, but in some countries, like Germany, there is actually no dispute resolution. Instead, if you have a domain name infringement happening in Germany, you will actually have to go to court in order to dispute the name back to you. Why it might make sense to also in a country like Germany apply a much more broader and proactive domain name strategy. So on your domain names, you can both have them as a part of being proactive, but then also selective in certain countries. Please remember to involve IT and make sure that you have the right trademark protection as sort of the foundation to be protected in the back. So now over to something a bit more maybe positive and interesting of these online IP protection programs, and it's the business intelligence that you gather through these programs. Since we are scraping the internet, we are gathering a lot of interesting intelligence around your products, around your brands, about market presence and so forth. And we have some good examples of clients discovering a need for their products on markets where they didn't exist today, or finding new licensing opportunities, for example. And I have a few of them to share with you here. We had one client discovering both counterfeit goods but also grey market imports of their goods into a number of South American countries. Interestingly, it made them be aware that, hey, these countries or the people in these countries are actually interested in buying our products. We are only in Europe today, and suddenly we are now also being sold in South America. This made them actually take the step and open up locally in a number of South American countries. Another example are a client of ours doing computer and mobile games. They actually found a lot of merchandise being sold with their products online. So it was a lot of t-shirts, it was posters, it was a little bit of everything containing some of their titles. What they realized then was that there was an interest from their sort of users and fan base of their games to actually purchase merchandise around their games. And instead of enforcing, we actually approach these sellers with the possibility to, instead of selling these sort of infringing products, actually turn it into a legitimate business and strike a licensing deal instead, which suddenly helped this client to find a completely new revenue stream actually. These are just a couple of examples. There are more out there, but I think that they serve as good examples of something positive coming out of the IP protection programs and not just enforcement. Hopefully you can take maybe some of these ideas and inspire you. So rounding off on the online IP protection part, one can conclude that by using this program as online IP protection, not just online brand protection, you allow yourself to leverage all of the upsides from the different type of IP rights that you have in your toolbox. That is one part. Remember to use the business intelligence to more than just enforcement. And maybe you can even find some new revenue streams by doing these programs actually. Thank you.